Hello there, Tom Hickey here from Dublin City University and a member of the Expert Advisory Group to the Citizens' Assembly. We thought it might be useful to you in advance of your deliberations on Article 41 to talk a little bit more generally about the Irish Constitution and indeed about constitutions. What's a constitution for? What typically goes into a constitution? Where does Article 41 sit vis-a-vis the other rest of the Irish Constitution, and to talk a little bit about amendments of the Irish Constitution. Before I attempt to answer those questions, I should point out that there is no set of golden rules on questions of that kind. I mean, constitutional law is not a hard science. And similarly, I should point out that constitutions, while around the world, while they're so similar to one another in certain ways, are so different from one another in other ways, so some of them are very old. So many of them are post-war, post-World War II, indeed post-1989 documents. Ours is a 1937 document, and that has an effect of a certain kind, particularly actually in the way Article 41 is drafted, as it so happens. But I'll talk about that later on. Some constitutions are very long, I suppose, and a bit more comprehensive, and then others are more succinct. So again, there's no hard and fast rules on these questions. So first off, what's a constitution for? And what typically gets addressed in a constitution? Well, I'd say the answer to that is a constitution fundamentally is concerned with establishing the institutions of state. And by that I mean basically, in our case, the Oireachtas, Dáil, Seanad, the presidency, the government, and the courts. Our constitution, most of it, from the start all the way up to there are 50 articles in our constitution. Right? You're interested in Article 41, of course, but there are 50 articles, and most of the articles from the preamble all the way up to Article 37 have to do with those institutions: Dáil, Seanad, courts, government, presidency. What are the powers and functions of each, and what are the limits on the powers of each, and how do they operate procedurally? So in other words, most of the Constitution is procedural, pretty technical. And then there is that fundamental rights chunk, in our case, from Article 40 through Article 44, and of course we're dealing with Article 41 on the family. Right, if you think about what a constitution is for, I guess in that light, what you would say is, well, first off, it's for establishing these institutions and their powers and functions and the limits on their powers. And then in the rights chunk, saying, look, these are certain things that are enormously important, and the institutions, government and parliament basically, cannot do things, enact legislation or exercise power in ways that breach these rights. Let me comment then a little bit on how rights provisions of constitutions tend to be drafted. I would say first that drafters of rights provisions the world over tend to want to avoid detail. And they tend to want to avoid drafting a rights provision in such a way that the provision would be prescriptive with respect to particular matters, particular political controversies or social matters or whatever. In other words, rights provisions, for good reason I think, and I'll talk about why I think that momentarily, they tend to be general rather than specific, broad rather than detailed, and to not be, as I say, prescriptive or authoritative rigidly with respect to particular matters, everyday matters, if you like. So what it means in the end is that rights provisions tend to be really made up of broad statements of moral principle. Everyone enjoys the right to a private and family life. Everyone enjoys the right to freedom of expression. Now, I said that there were, I thought, good reasons why rights provisions of constitutions would be general and broad rather than detailed and specific. So let me elaborate. Now, there's a few reasons, but they all boil down to the idea of democratic legitimacy, really. Take, for instance, the fact that constitutions are difficult to amend, right? For a good reason. by comparison with legislation. We amend legislation, or legislation is amended routinely. And what that means is, once you insert a provision into a constitution, it stays there for a long time. It's binding not only on this generation of citizens, but on several generations potentially of citizens. And as we all know, political views, social attitudes, etc., evolve a great deal over decades or over time. And so if you insert something that's quite specific or quite detailed into the text, well, then it's more likely that you run into democratic legitimacy problems down the tracks. In other words, that you have this binding constitutional provision that is not in line with the values or whatever of a later generation of citizens. So that's one reason to be general in a constitutional text. Another reason is that we don't find it easy to anticipate the kinds of cases that come before the courts. And it's remarkable the different ways in which constitutional provisions can have a bearing on particular cases. And what that means is that over time, a provision comes to be understood quite differently. That is, it's interpreted in the context of a particular case, and that's binding, and then subsequently influences later interpretations. And over a decade or 4 or 5 or 6 decades, well, then the impact, if you like, the meaning, the interpretation of a provision can come to be quite different from the meaning that the drafters of the provision had in mind, or the voters who voted for the provision had in mind. And again, obviously that problem is more likely to arise the more detailed the constitutional provision is. Finally then, on amendment of the Irish Constitution, as you know, there has to be a referendum for there to be an amendment, and the people get to vote yes or no to a proposal, and the proposal then will be on the ballot paper. And sometimes the proposal will just be to repeal a word, to remove a word from the text of a clause of the Constitution. The blasphemy referendum from a few years ago, for instance, was just to remove the word blasphemous from a clause in Article 40, Section 6 of the Constitution. We voted yes. More typically, an amendment would involve what's called repeal and replace, repealing lots of words, or a few clauses perhaps, and replacing it with a few words, or with lots of words, or with a few clauses, or whatever. It depends on the circumstances. The abortion referendum would have been an example of that from a few years ago, Repeal the Eighth, where a big enough chunk of text actually on abortion, the right to life of the unborn, equal right to life of the mother, right to travel, right to information, there was actually a lot of detail, as it so happens, in that particular episode. In the Constitution, in Article 40, Section 3, all of it repealed and replaced with a very simple provision that said, provision may be made by law for the termination of pregnancies. In other words, this is a matter for the Oireachtas. With respect to Article 41, it is hard to say. Of course, you've got the woman in the home clause, which I know you'll be talking about. So you would have a repeal option, which would be delete, or repeal and replace. Right? And then with respect to Article 41 more generally, difficult to say, really. It would depend on your preferences, as to what you want to do. So I hope that's been helpful. Thank you very much. Bye-bye.